Hi, this is Mike Brown from the New York State Notary Association with another quick review. So we're going to dedicate this newsletter review to practicing law illegally, which is the criminal charge of criminal contempt. And that's when a notary public's giving legal advice, and it's a Class A misdemeanor, which you should know is mandatory sentencing if convicted to 1 year maximum in jail. Not good. Also, of course, you could lose your license and have it suspended once you've had a copy of the charges against you and an opportunity being heard. That would be in a tribunal hearing or a state licensing hearing. So even if you did it by accident, you could still lose your license, although it wouldn't be a Class A misdemeanor, because a misdemeanor or a crime is when they prove you did it with an intent to deceive and injure and gain a benefit. So even if you're making a mistake because you're ignorant, you can still have your license suspended or removed. Okay, so here it is in the statute. So any person violating the provisions of these sections, which are acting like an attorney when you're not, you'll be guilty of a misdemeanor. And who can bring you up on those charges? This is under power of courts to punish for criminal contempt. The Supreme Court has power under the section to punish for a criminal contempt any person who unlawfully practices or assumes to practice law, and a proceeding under the subdivision may be instituted on the court's own motion or on the motion of any officer charged with the duty of investigating or prosecuting unlawful practice of law, or by any bar association incorporated under the laws of this state. So what we're saying here, folks, is that any attorney in your local town who sees you doing this can bring you up on these charges. So illegal practice of law by a notary public is to make it a business to practice as an attorney at law, not being a lawyer. It's a crime. You're giving counsel and advice, the drawing of agreements, the organization of corporations, and the preparing of legal papers connected, like drafting of legal documents of all kinds, including wills, are activities which have long been classed as law practice. And it goes on to say in another section of law, I don't have it here, but you're not even allowed to notarize somebody's signature to their own will because you're in effect practicing law without a license. So don't notarize somebody's will. You can notarize the two signatures of witnesses that come after a will because, after all, they don't need legal advice. It says under the law that when you notarize somebody's will, signature to their own will, and you're not also licensed as an attorney, you are in effect practicing law, and that you're encroaching upon the legal profession, and you're also providing the risk for that person whose signature you're notarizing of, losing their property that they're bequeathing to somebody. So those are the reasons given under the law. Okay, so the sentence of imprisonment for misdemeanors or criminal contempt practicing law without a license is a definite sentence, which means it doesn't prescribe the minimal sentence like some felonies that a notary can do. It could be a Class D felony, which is a minimal 3 to 7 year max. This one doesn't prescribe the minimal sentence, so it's just a definite sentence. So what does that mean in reality? Probably you're going to get a probation the first time. And there is a 1 year. It shall not exceed 1 year. So 1 year maximum. Not good for you. Not good for your resume. This is kind of interesting. This is, pretty recent in the last year. Advertising. A notary public who is not an attorney licensed to practice in New York State shall not falsely advertise that he or she is an attorney licensed to practice law in the state of New York or in any jurisdiction of the United States by using foreign terms, including but not limited to abogado, which is Spanish, mandataire, procurator. I can't read these, folks. So anyway, a notary public who is not an attorney licensed to practice law in the state of New York and who advertises his or her services as a notary public in a language other than English shall include in the advertisement the following disclaimer. I am not an attorney licensed to practice law, and I may not give legal advice about immigration or any other legal matter or accept fees for legal advice. I was called by the Long Island Newsday magazine about this to interview what we thought about this paragraph here. You have to put this in a sign in whatever language in a neighborhood you are advertising that you're a notary. I am not an attorney licensed to practice law and may not give legal advice about immigration or any other legal matter or accept fees for legal advice. Folks, this is because in most other countries, people who have a notary license are licensed attorneys at law. Okay, for example, in the Philippines, which was once a Spanish colony, they have a lot of Spanish in their language, and abogado is Spanish for attorney. So people who come here from South America and the Philippines, they see that you're a notary, they can immediately assume that you're a licensed attorney with a 4-year, degree, bachelor's degree, and then a Juris Doctorate degree from law school, and that you've passed the bar exam. When in reality, in New York State, many of you are aware that we're only required to have common school education, which is actually somebody who could even be a high school dropout, not close to being a degreed attorney at law. So here's the examples they give in the New York State statutes for Chinese, Spanish, Korean, and Haitian Creole, which is like French. And that's what they give you in the New York State law. So that's this month's review to keep you from being complacent and making these common mistakes that people make. I hope you're having a good month. I hope you had a good summer. We'll see you next month with another review.